Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will & Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, the flagship publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed some recent intellectual property cases that the U.S. Supreme Court decided. This podcast will discuss the significance of prior art, which is the topic of the August 2014 column in Computer Magazine. Joining me today is my co-author of the August column, Bruce Rubinger. Bruce is the founder and managing director of Global Prior Art, a firm that specializes in patent research and prior art searching. Welcome, Bruce.
Thank you, Brian.
Bruce, before we get to some of the specifics about prior art, why don't you tell us what Global Prior Art is and what it does?
So Global Prior Art is an intellectual property research company that has a rich history that spans more than 30 years. I created Global back in 1982, and it represented an extension of my work in innovation and strategy. I'm a technologist, and this has influenced the evolution of the firm. I'm a lifetime member of the IEEE, hold a BS and EE, a Master's in Control, and a PhD, which focused on estimation and prediction. Global Prior Art is widely viewed as a technology powerhouse. Our engineering division consists of 4 groups: electronics and ICs, software and business methods, telecom, and mechanical/consumer products. And so the work we do includes invalidity studies. We do a lot of due diligence for firms that want to acquire patents or acquire companies, a lot of freedom to operate types of searching. We do a lot of competitive benchmarking for senior management and chief technology officers. We do a lot of accelerated exam searching. And Global is also a pioneer in the field of IP landscapes, and we've been doing that for more than 20 some odd years, very detailed landscapes that are used by clients to understand the opportunity areas that they should focus on.
Thanks. So, in our column, we talked about the definition of prior art, which includes issued patents, published patent applications, and other publications that existed before a certain point in time. In view of the evolution of search tools, how do you approach searching for these different types of prior art? What's the relative difficulty in searching for each type?
So, the body of prior art is extremely large, and as you point out, it includes patents, published application, literature, products, foreign patents, data sheets, etc. And so searching is really not about searching. So behind a successful outcome really is the ability to address the following issues: where to search, what to search, and how to search. And because of our extensive institutional knowledge, we are able to effectively address these critical issues before any searching takes place. For comparison, we've often been asked to take over a case where there's been significant searching previously, often many months of work, and we uncover in a few weeks critical prior art that was missed. So the important thing here is not searching, but understanding where to search and how to search.
Well, how about the difficulty in searching and how to search based on the subject matter? For example, is it easy to search for software-related prior art compared to hardware-related prior art?
So every body of prior art, every body of technology has a very specific body of prior art that's going to be relevant. So when you're dealing with a software-related matter, prior art often comes in such forms as products, software code, industry reviews, user discussion forums, as well as published patents. So the approach to finding prior art in each of these categories will vary. We've collected over the years many products and user manuals, and we have really a large in-house library of such sources that we've collected and organized over the last 30 plus years. And so with software, really, it could come in any of those sources can be very important.
Well, how about the time effort? I assume that the amount of time needed to search depends on the requested depth of the search. However, in general, are there typical time allotments, and how do they depend on the technology at issue?
So the time for a search is driven primarily by the nature of the technology, the priority date, and the claims. And so one of the things that we've done is, since we've already handled close to 10,000 cases, we could effectively determine where to search and what are the most relevant areas to cover and how long it's going to take. So if you're dealing with software patents or business methods, the most relevant art is going to come from U.S. patents and critical U.S. literature. And in addition, product data sheets and data books may also be important, so this could add some time to that. So once again, if that's where you're going to look for software, those are going to be the most critical sources. If you're looking overseas, if you're looking in China or India, you're wasting your time because you're not going to find prior art in those areas, and so it's really important to focus on the U.S. On the other hand, if you're dealing in electronics, in addition to the United States, Japanese prior art is going to be very important. Once again, a Japanese search means manually going through Japanese patents and utility models, which are by definition Japanese. And there's a lot of Japanese art. Since everything is published in 18 months, it will typically require 4 to 5 days of someone fluent in Japanese to go through and cover Japanese art. And when we do that, the work is carried out by our full-time staff based in Tokyo.
Let's assume that the search is completed. There's usually a lot of material to examine and evaluate. What's the best way to compile and present the results of the search? Are there particular formats that are well suited for this?
So our clients, especially for fields of litigation-related matters, they're extremely busy. And so it's really essential that the findings are organized in a manner that's going to facilitate their review. So typically what we do is we organize the findings as Tier 1, which would be the 102 art, and the Tier 2 findings, which would be the 103 findings. And we'll often walk clients through the findings by phone to facilitate their analysis. Typically, the questions are always the same. What are the best findings? What do they cover? How closely do these findings map against the claims? If I needed to cover some of these dependent claims, what would be the best Tier 2 findings? What are the best combination findings? So it's really important to work closely with clients as part of their team. We also do a lot of work that's for product development teams. And so in these cases, the findings are going to be used both to do clearance search, and it's also going to be used to guide the further development of the product. So when you're doing working with a product development team, we'll devote significant time up front to understand the key features of a new product, as well as how the findings are going to be utilized. Many features are fairly old, and clearly those are going to be well known in the art, and patents are going to be no longer in effect. But you really want to know what is the novelty, what are the key features, and that's really critical. And then at the conclusion of the study, we typically have a meeting with the product development team to walk through the findings, the landscape where they're engaged, help them understand the key patents, help them understand the positioning of competitors, and which product features they should emphasize as they go forward, as well as the opportunity space. What's really important here is senior management recognizes the importance of the product development teams understanding the IP space and filing strong patents. But it's not enough to make that an imperative, because technical people don't have the time and expertise to go through thousands of patents to figure out which ones are relevant and then to analyze them. And so the work we do by creating these landscapes, it's clear within 20 minutes to the team members how they're positioned. And it really gets them excited because for the first time they really understand IP. And in many cases at that point, product development teams will sit down with a day or two later and they'll be able to figure out where they're going to file patents, actually to write patents at that point in time. And so you really have to be able to provide your product development teams with the tools that they need, the ability to file strong patents, and this is one of the things we do. Another area that we've seen a lot of interest in recently is there's a lot of benchmarking now, which is being initiated by senior managers and chief technology officers. Basically, the interest is understanding their filing activity, whether or not they're spending enough money on patents. Are they filing too many patents? Are the patents properly aligned with the product development going forward? And so, once again, it's really important to interact closely with the teams. They have a lot of perceptions. They're usually companies they want to look at initially and understand what they're filing, how relevant it is. But it's also important in this case that we work closely with them. We'll always try to set up a meeting and brief them on the findings, what they mean, because senior people don't have the time to go thumb through reports and figure out, what's really relevant. They really want someone that's going to walk them through the key findings and explain what it means.
Some of these tasks that we've been talking about likely would occur in a patent infringement lawsuit. Does your timing or approach differ when you're involved in patent review or reexamination procedures at the U.S. Patent Office?
So the timing really is pretty much driven by the timeline of the law firms, the lawyers we're assisting. The ITC matters, you have a really short timeline, and so we really put together a squad that could respond quickly to those because often they need the findings in 2 to 3 weeks. Sometimes with the re-exams, they need the findings fairly quickly as well. The other thing that's going on is the searching right now tends to be much more thorough. We see a lot more activity that's being initiated by joint defense groups, and because the stakes are so high, they really want a comprehensive search. And so we're being asked not only to cover U.S. sources, but to cover Japanese sources or Chinese sources, or in German language patents and literature as well. But it really depends on the venue and timeline of the team. So, for instance, right now, a lot of U.S. companies are actually involved in litigation in the European Patent Office. And once again, we see those tend to be fairly short-term. They need quick turnarounds, 2.5 weeks for those type of activities.
So you talked briefly about product development teams and so forth. Let's say a company wants to research whether a potential new product might be covered by someone else's patent. This is important for the company to do, clearly, before it spends resources on developing a product that perhaps it can't sell due to somebody else's patent. How do you approach that type of search?
So that's a really interesting question, because what's really interesting are who are the stakeholders and who's going to kick off a search like that. What we're finding is that in many cases it's the VCs who are investing in a company, and they know the company has a terrific idea, and the VCs want to make sure that they have a strong patent. So it's the VCs want to know who is out there, and they want to make sure that these firms are going to file strong patents, because small firms are so busy dealing with product development, raising money, and other things that they only give lip service in many cases to the IP activity. So every firm operates in a crowded space, and so it's really important to have a good sense of the intellectual property and how you differentiate over the prior art. Now, an example of one of these cases is the work we did back in 2009 for this company, Bit9, which is a security software firm on 128. And so the founder, Todd Brennan, had come up with a terrific idea in the field of security technology and was in the early stage of building a firm. And we were approached by his VC investors. And so their overarching issue was to understand what patents were out there and how do you go about creating a valuable portfolio that would protect Bit9 from competitors. So in this particular space, there were more than 10,000 patents, many of which were held by large software companies. And when we went through the body of art, we ended up flagging about 153 patents which were relevant, and we created an IP landscape map for Todd, which broke down the patents by different technology branches and different security mechanisms. Todd then used that going forward, both to file strong patents, and he also used it in his briefings to the board, and they used it also when they raised additional funding. A couple of years later, Todd told me that he filed 5 major patents based on this analysis, and each patent increased the value of Bit9 by more than $1 million. It also provided a critical database that he was able to use later on when he did get some infringement letters, and all the patent information in the database he was then able to mine and deal with these infringement letters, just showing that those patents should not have been granted because there was prior art against them.
Interesting. For the engineers and scientists out there, IP research sounds like a good career path and a chance to have some impact. What expertise do you look for when recruiting people to help you in these types of positions?
So right now we're actually recruiting for our telecom team and our software team, and as you point out, this is a really interesting career path because you're all constantly dealing with new technology, and every day, you have a new patent or new technical field to look at, or you're looking at some technical issues from a slightly different perspective. Number one is technical strength. So we really look for people who really have strong technical backgrounds. Two, they have to have a broad background because, it's not just semiconductors. It's going to be circuit design. It's going to be some other areas. And so you're looking for people who like to learn about new technologies. Attention to detail is really important because IP is all about claims, and claims is really about the small aspects which allow one patent to distinguish against other patents. And so you really, really want people who have that level of detail. And then you need good communication skills because at the end of the day, you have to be able to communicate the top findings to your client. And so those are really the skills that we look for when we recruit.
Thanks, Bruce, for your views on this topic. We hope that you found this podcast helpful. Please stay tuned for the next month's column in Computer Magazine. Until next time, this is Brian Gaff.
Thank you, Brian. It was a pleasure to be here today dealing with these really very timely issues.
Thanks, Bruce. Feel free to contact us via email at bgaff@mwe.com or at Bruce's email.
It's Rubinger@globalpriorart.com.
Thanks.